Mr. Chairman and directors, we will resume the training for today. I believe our Zoom participants are in place as well. The next presentation will be an overview of tax abatement transactions and related financing mechanisms. Will be presented by Douglas Selby with Hunton, Andrews, and Kurth, and he has an associate, which I believe you will introduce as well. Mr. Selby, the floor is yours.
Well, good afternoon. Thank you for inviting us to such a beautiful location. Really, it's enjoyable just to be here with you.
We can't hear him.
Okay. I need to speak louder. And I'm going to move the mic, sir, closer to me. Is that better?
No, sir.
Okay. Turn the volume. You want me to hold it?
Can you hear us now?
We can hear you, but you're still in the background. I think if you pull the mic, just pull the mic closer.
Is that better?
That's better.
Okay. All right. We'll pass the mic between us. We'll hold it. And just
Perfect.
Holler if you can't hear us, please. Thanks.
Yes, sir.
So just again, thank you for having us. I'm Doug Selby. I'm a partner at a law firm called Hunton, Andrews, Kurth. We are in the Atlanta office of Hunton, Andrews, Kurth. We're one of the large international firms. We've got 1,000 lawyers and 17 offices around the world. I run public finance for our firm. I'm co-lead for public finance nationally. Where we do public finance for in Georgia for many entities like we're bond counsel for the city of Atlanta. We do all of the financings for Hartsfield-Jackson. Similar transactions, we represent Invest Atlanta, which is the Atlanta Development Authority. That's their DBA for Atlanta Development Authority. We also work with Decide DeKalb on a number of its abatement transactions. Some of the interesting projects we're working on right now include a $5 billion rebuild of the Atlanta Gulch, which is the area between Mercedes-Benz and State Farm Arena, which is a combination of incentives, some of which are part through their Downtown Development Authority and part through a tax allocation district that the city has in Atlanta. That's the subject of some litigation. We won the biggest piece of it, but that's sort of the kind of work that Ben and I and the other lawyers at our firm that do public finance do. So I do public finance. That's all I do. Have a small representation. I represent a church denomination internationally, but 90% of my practice is as a bond lawyer. Been doing it for 25 years. I'm a native of Atlanta. I grew up going to movies on Old National. So, I mean, this is South, this area is where I grew up. Ben Vernon is with me, and I'm gonna let Ben introduce himself, but he's works on our public finance team.
Thanks, Doug. And like Doug said, if you have a problem hearing me or you can't hear me at all, just holler and I'll put the mic closer to my mouth. But I'm Ben Vernon. I'm an associate with Doug's team at Hunton Andrews Kurth. I joined them in 2018 from another bond firm in Atlanta called Murray Barnes. So I've been doing this for over 4 years now. And like Doug said, we do a lot of these tax incentive lease purchase deals with various development authorities across the state. And we're excited to be here. So thank you.
Yeah. So we thought today, really, we have a structure of the discussion today, but I'm open to a touch on anything that you care to have us touch on. So we'll look to you for guidance if we miss something or you have questions about something. I overheard a conversation. Do you want us to go all the way through and then do questions at the end? Is that whatever you prefer?
Yes.
Okay.
Probably be best.
All right.
But I know in your introduction you made reference to what you guys do in other municipalities, but when you say things like tags, stuff, I would appreciate it if you could just give a brief overview.
Okay.
of acronyms.
Yes,
You
yes,
didn't
yes.
say TAD, I thought TAD when you said it, but I still feel like.
Yeah. I will be sensitive to the use of acronyms, which our practice is replete with them. So I'll be careful to do that. But as you know, TAD is a tax allocation district. And I recall that you just put that on a referendum and it was approved, correct?
Correct.
Right. So you have TAD, and everywhere else in the country, they call it TIF, tax increment financing. Georgia, they call it TAD, tax allocation district financing. It's just our statute calls it TAD. But in fact, my firm, we were the first TAD that was done in Georgia was for Atlantic Station in 2001. And our firm served as bond counsel for the Atlantic Station TAD and some of the others around the state. But TAD is really another tool in your toolbox. We're talking about one tool today, which is tax increment financing. TAD, tax allocation district, or TIF financing, is another powerful tool that, frankly, we've seen in some other markets, some other cities. The development authority frequently partners with the city to implement that incentive. In many instances, we've seen the development authority serve as, quote, the redevelopment agent for the city in implementing the redevelopment plan that's part of a TIF stretch. But we could talk on that one for a while, but I'll focus on today the tax abatement incentive that is a common tool used by most communities in the state. What we'll talk about today is just an overview of what they are, how the transactions are structured, what the relative benefits are between the businesses that are receiving the incentive and the governments that provide it. We'll give you some examples and, frankly, some cautionary tales about things that you might consider when you're doing transactions in terms of whether an incentive is too deep, meaning you're giving away more in tax dollars than you care to, guidance for judging when an incentive is appropriate in terms of the public policy and when it might not be. And then we'll go through some what we believe are best practices, show you some incentive schedules that are commonly used, and then some what we call clawbacks. Oh, thank you very much for a table. Thanks so much. Thank you. Let's see. Might help us. Yeah. And then some what we call clawbacks, which are structuring devices that if you don't get the benefit of your bargain, you're able to impose a restriction on the developer. So that's what we're going to talk about today. And then at the end, we can go through some samples. I'm aware that there's one medical office project that is currently being considered by the authority. And with the city attorney and I have been talking about that, and there may be a recommendation for that to be on your agenda at one of your upcoming meetings. So let's go through it. Ben's going to lead us through the slides. So Ben, I'll let you sort of take us away from the first slide. Okay. And sir, can you still on the screen, can you still hear us? Well, I've put the mic in a different location. Can you still hear us?
We hear you well, sir.
Okay, thanks.
Great. So now we're on the slide 3. Just a general overview of lease purchase bonds, and I'll kind of touch on this at a very high level, just in terms of what they are, why development authorities issue them, and what they seek to accomplish. So from a very high level, a lease purchase bond transaction is a way in which a development authority or other governmental body can provide a tax incentive to a private company or a private developer who seeks to input some kind of economic development project within the authority's community. And the reason that we have to go through this lease purchase transaction is because the Georgia Constitution bars gratuities provided to private entities. And we also have the uniformity of taxation clause, which basically says that governments can't enter into handshake agreements with private developers and just say, we'll give you a tax break, you come in, you do this project, and then we'll slash your taxes. The Constitution prevents that, so lawyers have kind of crafted different structures and different methods to accomplish the same thing, but through the issuance of so-called lease purchase bonds. Sometimes they're called sale leaseback transactions or bonds for title transactions. They all effectively mean the same thing, which is a ad valorem property tax incentive in consideration of the development of some kind of economic development project in the community.
So at its core, what we're talking about today is your authority has the power to cut a property owner's tax bills through this structure. And it's the city's ad valorem property taxes, the county's ad valorem property taxes, and the school board's ad valorem property taxes. Structured through this, what we're describing today, if you take certain actions by operation of statute, that developer will have a reduction in the amount of city, county, and school board taxes. So that's what we're talking about. And really, you as policymakers will have to decide if the project merits that kind of incentive. That's your decision. If you direct your attorneys to do it, that's the net effect of it, is you'll be cutting city, county, school taxes.
I'll add on one thing before we go to the next slide. These are contractual agreements when they're entered into between the private company and you as a governmental body. And so you can put certain mechanisms in the documents that will give you the ability to end the incentive if you don't feel that the private company is carrying its share of the bargain. You know, if they are not putting in the capital that they promised, if the project is not what they said it was going to be, they're not creating the number of jobs that they said they were going to create, that kind of thing. You can put things in the document to protect the governmental body. I think next slide 4. So what are they? Again, this is kind of a high level overview. They're bonds that the development authority issues, and in exchange for issuing those bonds, the private company will transfer title to the project that they're developing to the development authority. And when the development authority owns that property in fee simple, that property is no longer subject to ad valorem property tax. And that's where the incentive kicks in. And the way that they're structured is the development authority will lease the project back to the private entity. And that's how the private entity still retains a leasehold interest in the project.
Go to the next slide.
Next slide.
And let me just give one little bit of context. So and we do the incentive work for one large paper company in around the Southeast, Arkansas, Mississippi, Georgia, trying to think, Kentucky. Mm-hmm. And what we found is that Georgia's not alone. Many of the other states have almost identical kind of structures. So we do a deal for this company in Arkansas. They've got the same structure, which is transfer title to a government. Government doesn't pay taxes. Lease it back to the company. Then the company, you can structure a deal with the company about how much they will pay. Sometimes people call it a payment in lieu of tax. Sometimes it's structured as a estate for years, and the tax assessor says, okay, you don't own the fee simple interest in it. And in fee simple interest, maybe one of those other acronyms, Mr. Chairman, you know, real estate lawyers call a fee simple interest that you own all of the final ultimate rights in the property. They call that a fee simple interest. And we distinguish that from a leasehold interest. If you hold a leasehold interest, it's just, you know, as defined in the lease, the terms of the lease, a particular term, certain uses, all of those are described in the lease. And that's what we call a leasehold interest. The tax assessor says, you don't own the fee simple interest. South Fulton Development Authority owns that, but you have a leasehold interest and we're going to tax it. And that's where, when they tax that leasehold interest, it's less than if you paid on the fee simple interest. And that's where the incentive comes in. Want to make sure I explain that part. The other part I want to explain, we're about to describe some things with bonds. And it's kind of puzzling because I wouldn't say, well, this is a public meeting, but let me just say, some people call the bonds phantom bonds. I don't know if you've heard that term before, phantom bonds. And it's because the bonds we go through the bond issue in order to create an arrangement by which your authority can acquire the project and then lease it back. So on paper, we describe a bond issue in which you issue the bonds, you take the proceeds of the bonds, you buy the project, finance the construction of the project, and then you lease it back to the company. Ben's about to walk through it step by step. But the bonds are issued in what we call a notional amount, a hypothetical amount. They really aren't issued. We really aren't exchanging cash. It's like a paper transaction to allow us to check the box with the statute. And this sounds a little strange, but I'm telling you, every community in the state does it exactly this way. So whether it's the Kia plant, or we did the one for the NCR headquarters, for New Norfolk Southern headquarters, for even the building I work in, which is Bank of America Plaza, is in a similar transaction. So it's not what I'm describing is not an exotic financing structure. It's one that your peer authorities all do. Okay, but I wanted to describe that when we say the bonds, you're gonna say, gosh, Hunton's telling us we're about to issue $10 million of bonds. Do we want to do that? I will just comment that they're these hybrid types of bonds. They aren't real bonds. So with that sort of expectation, we'll let Ben go through exactly what we are structuring in a transaction.
And to that last point about, bonds being phantom bonds, that's why you can see on bullet 2, we use the word notional amount to describe how the bonds are issued. And that's because we don't necessarily know the exact dollar value of how much a private development is going to cost. Of course, there are budgets and estimates, and we can get a pretty good ballpark idea, but that's why we say the bonds are issued in notional amounts. And so we've laid out on this slide kind of the 5 steps of how these transactions flow in general. The first thing and we put them in 5 different steps, but they really are all going to occur simultaneously at the closing of the lease purchase transaction. So number 1 is the most important part, because that's how the property actually becomes exempt from taxes. And that's when the private developer transfers legal title of the project to the development authority. And that's what kicks in the exempt status of the project. The authority then issues the lease purchase bonds, and the bonds are purchased directly by the private entity. And at the same time, the private entity enters into a lease agreement with the authority. So the authority leases the project back to the private company. And that's where the term sale leaseback derives from. Under the lease agreement, the company has to pay rental payments to the development authority, because the development authority is now the owner of the project. And if they're going to enter into a lease, they're going to charge rent. So the way that we kind of circumvent the private company from having to make real payments is that we make the debt service on the lease purchase bonds that the development authority issues, the interest payments on the bonds are equal to the rental payments under the lease. And we have the little asterisk at the end, and as Doug said, these are cashless transactions. So the private developer is not actually making, annual rental payments, and the authority is not actually paying interest on the bonds, all of these payments cancel each other out. And the overall goal is just to provide the ad valorem tax incentive and, of course, get the community benefits.
So some people might say this sounds crazy, but let me just assure you that there are Supreme Court cases analyzing this exact structure, Georgia Supreme Court cases analyzing this exact structure. And so it's not just some dream of the bond lawyers in the state. It is something that they dreamed up before I started practicing. But it's been given the sanction of the Georgia Supreme Court. So when we do the transaction, you can do it with the comfort that there's case law supporting this kind of structure.
This is just a diagram that kind of breaks it down, just so you can, the point of this diagram is to show how the debt service on the bonds and the rental payments under the lease cancel each other out.
Let me just drill down a little bit on that. So again, Ben described bonds issued, bonds are sold to the developer. So the developer owns the bonds in a private placement transaction. Developer enters into a lease agreement with the development authority. Lease payments are equal to the amount owned by the bonds. So just as Ben was pointing out, the developer owns the bonds on which the developer is entitled to principal and interest, but at the same time, they've got to make a lease payment equal to principal and interest. So they pay themselves and it cancels each other out. But the one thing I think, just to be clear, the bond is purchased by the developer. The bond that you issue, we're not selling it in the bond market the way that, for instance, South Fulton sold bonds or tax anticipation notes or anything like that to an underwriter or an insurance company. We're not really selling it in the public markets. It's a private placement to this single developer. They buy their own bonds.
This slide shows generally the principal players on a typical lease purchase transaction. You have the issuer's counsel, lessee purchaser, lessee's counsel, trustee bond counsel, lender and lender's counsel. And all of these, different parties are working together to accomplish the same thing, right? The private company, they want their tax abatement, and the government wants their community benefits. And then, sometimes you have a lender, if the private developer is financing the project through a bank loan. Sometimes the lenders want some certain documents executed so they know that they have comfort that the development authority is not going to retain title to the economic development project, but that this whole transaction is structured in a way that at the end of the incentive period, the private company will be the official owner. Let's see. Then slide 8 kind of just, a lot of legal jargon and technical terms on this slide, but these are the standard bond documents that would be drafted and signed by the parties in a lease purchase transaction. Of course, you have a bond resolution, which is the development authority's sort of official certification that, this is what they want to do, this is what the government wants to do. And then you have all of these structural documents that are in place. The lease is probably the most important one on this list, just because that is where you're going to drill down on what kind of community benefits must be met by the private company in order to obtain the tax incentive. You've got different insurance and indemnification provisions, which we'll talk about a little bit later. You've got clawback provisions, just a host of different things. The other item I'll point out, number 7 is a memorandum of agreement. Do you want to talk about that?
Yeah, maybe just touch on the memorandum of agreement. So in addition to you, the development authority approving this transaction, In Fulton County, we also are able to get the Fulton County Board of Assessors to acknowledge the arrangement that you've just created. So the tool that we use to get them to acknowledge it is a memorandum of agreement regarding leasehold valuation methodology is what it ends up being. And it's going to be in a tri-party agreement. It'll be the developer, the development authority, and the Fulton County Board of Assessors. So once your board agrees to do this, typically your bond counsel will approach the the Fulton County Board of Assessors. The chief appraiser in Fulton County is Dwight Robinson. We get on the agenda of the Board of Assessors and we present your project to the board. And they will then sign a memorandum of agreement that basically says that they will tax the leasehold interest in this abated format. And then there's another slide that shows the ramp up. We're going to show you the math behind it. But the bottom line is that we're also going to the Board of Assessors, that entity that actually assesses the taxes, and they're signing off on this. And in Fulton County, they do that. They don't do that in all counties. In Fulton County, they will sign it. Like in DeKalb County's tax assessor, they won't sign the agreements. But in Fulton County, we go to their board and they all sign the agreements. And it's common. So on a given agenda meeting for the Fulton County Board of Assessors, it'll be the Fulton County Development Authority, it'll be the Atlanta Development Authority, it'll be the Alpharetta Development Authority. I mean, all of us are lined up, sitting in the hall waiting for our agenda items to come up. So this is, again, a fairly common thing, and you would be your deals would fall in line with theirs.
I'll also hit on, before we go to the next slide, I just want to hit on number 8, which says validation documents. And that's something unique to Georgia, which is, it's called the bond validation process. And basically what it is it's getting the Superior Court's blessing that this transaction is lawful. This transaction follows a reasonable, non-arbitrary methodology. And it gives everyone who are party to the documents, the development authority, the private entities, gives them a little bit of comfort that a Superior Court judge has actually signed an order stating that this transaction is valid under Georgia law.
Talk about paragraph N.
Sure. So the benefits, obviously, jobs is a huge one. We're actually seeing sort of a trend that, when times are good and the economy is rolling, sometimes communities want to add, separate kinds of benefits into their programs, whether it be public, a requirement that the project meet some kind of public infrastructure, public transportation project, whether they want, the developer to provide internships to students in the community. You can really have a flexible structure here on what you want. And you just have to all come to an agreement and negotiate the terms with the private developer. Doug was pointing out a code provision under Georgia law, which is 3662 26N. And that is a provision that it's called the catch-all provision under the Development Authority's law. And it basically allows a development authority to do a lease purchase transaction on any kind of project that promotes employment opportunities within the state. And there have been some recent cases on what you really can do and what you really can't do, because that's, very broad. Promotes employment opportunities. What does that really mean? Can you build a golf course? That was a case a few years back where the court looked at whether or not a municipal golf course constituted, trade or commerce and promoting employment opportunities. And so it is a very broad paragraph, and you do have a lot of flexibility, and we've done a lot of different projects.
Yeah, and then just the history on it is that the statute is a statute that says what's a permitted project. and the statute kept getting amended. People are like, well, is a grocery store an economic development project? Is a office building or a hotel? And it kept getting amended piecemeal. And then they added paragraph N, this catch-all. And it's really interesting the way the courts look at it. So right now in the statute, it'll say you can't do office. But paragraph N was adopted later in time. And now the Supreme Court has said that the paragraph N controls in terms of statutory interpretation because it's adopted later in time. And what it basically says is if a majority of the members of the authority adopt a bond resolution that declares and makes the finding that this advances trade, commerce, industry, and employment opportunities, then I think absent the court thinking that you've acted arbitrarily, they will support you in their decision because the court says we're not fact finders. We don't substitute we're not the fact finders. You're the fact finders. You're the policymakers. So we're not substituting our judgment for yours. As long as we're convinced that you didn't do it arbitrarily, they support the finding that you make on that point. And it's a powerful provision. Ben is talking about a case. It's a case up in Cobb County, the Kroger case. And there was a challenge to it about, come on, Kroger, you're renovating an existing Kroger. So therefore the claim was you're not creating new jobs. And the court says, nope. Board looked at it and they either thought that you were going to lose jobs and you needed to retain them, whatever they did it, but it wasn't arbitrary. They've got the discussion to support it and they upheld it. So it's a powerful tool that you have. And the only caution we would say, if whoever your lawyers are drafting this up, I know our firm is careful I have a whole section in my bond resolution called findings. And I kind of pepper that just with a challenge in mind. We're probably a little jittery because we do a lot of work in Atlanta, and Atlanta's got a lot of people that challenge their bond issues. So we're always, every time we do a bond issue, we're preparing as if we might be challenged. And that's one of the things that we've done in that setting. It's a powerful paragraph. Let's try to get into the math to make sure that we see how one of these deals impacts the community. Ben, you want to?
Yeah,
let's get to.
I think slide 11 is probably
Yeah.
a good place to start.
Get into the math a little bit.
Yeah. So this is, we're going to just, the next couple of slides, walk through an example of how this might work. Here we have a, company X, which owns land in the city of South Fulton. The undeveloped land has a value assessed by the tax appraisers, or appraised by the assessors at $1 million. The millage rate, and we calculated this looking at the Department of Revenue site, so it's an approximate rate for South Fulton, and it includes the city, the school, and the county, is around 40.471 mils. And we've said that if the
Does that sound right? Does that sound right?
the millage rate for
40
South
mils?
How many minutes?
40? Oh, for everything.
Oh, for everything.
For city,
county, and
county.
school.
Oh, yeah, with everything.
Oh, yeah, no, I wouldn't know. I don't know.
Okay. That is right?
That's
Okay.
all right.
Okay. And so if the land remains undeveloped for 10 years, there's no, private company that comes in and does a big project on it. We've calculated the annual taxes that would be produced from this $1 million parcel of land at $16,000 and $188 per year. And that's a cumulative over 10 years of $161,000. And then can we go to slide 12? And now we say that the company that owns this undeveloped land is considering some kind of economic development project. I think the example we used here is a manufacturing facility. And Company X estimates that if they build this manufacturing facility over the next couple of years, it's going to have a new appraised value of $10 million. So they would have added, $9 million worth of improvements to their $1 million undeveloped parcel of land. And then we say that Company X and the Development Authority and the Fulton County Board of Assessors all enter into a memorandum of agreement. And this assumes that, the Development Authority has signed off, adopted a bond resolution, and wants to move forward with a lease purchase transaction on this $9 million development. And we've shown here the abatement schedule that is most commonly used in Fulton County. And what it does is, in year one, after the project is up and running, the company gets a 50% ad valorem property tax reduction in the first year. In year two, they only get a 45% reduction. Year three, a 40%. And then you can see it gradually goes down after year 10 to where they're paying full taxes on their project. Not all communities follow this leasehold methodology, but this is the standard one that's used in pretty much all of Fulton County transactions.
Yeah, and it's just the policy of the chief appraiser or the board of assessors, and the chief appraiser working for the board of assessors. And in Fulton County, there's no discretion. It's 50 every deal, whether it's new corporate headquarters for NCR or it's we just did a bakery, a manufacturing facility for a bakery. Everybody gets the same schedule, and they call it a ramp-up schedule. DeKalb County, lots of variation in DeKalb. Outside of 285, you see all kinds of schedules outside of 285. And there, people, those communities, it's largely for manufacturing, and they want the jobs. And so if Georgia Pacific comes and says, I'm going to build a plant and I'm going to bring 1,000 jobs, they're going to get an aggressive abatement schedule. What we found is that in some of the more urbanized communities, there tends to be a more conservative abatement schedule. And the one thing about Fulton, and the thing that I think has kept them out of a lot of litigation, is that they don't vary. It's a uniform approach. Big company, small company. It's the same math. There's going to be one exception that Ben will describe called a usufruct, but if it's a lease, a state for years or lease purchase where we're valuing the leasehold interest, this is the schedule that the Fulton County Board of Assessors and their attorney will sign off on, and none other.
And it's really a good practice by any community. Well, by communities that are close to large metro areas or in large metro areas to follow a uniform schedule. So we've seen it in other jurisdictions that kind of have more flexible schedules that sometimes it can create some issues. Sometimes concerned citizens don't understand why one company is getting a huge abatement and another company is getting a really small one. And so we'll talk about in our best practice slides that having a uniform schedule is really beneficial to all parties.
Slide 13.
Yep. So now we're showing the 10-year projections of taxes, assuming that the company goes forward with their development. And and on the far right, we're showing the taxes, assuming that the company never went forward with the project. So you can see that although the company is getting, a fair amount of tax savings, if you look at column 3, it shows how much they're paying. If you look at the very first column, it's showing how much they would normally pay without the lease purchase incentive. And then if you look at column 4, it's showing how much they're saving each year. So over 10 years, they've saved $445,000. Seems like a fair amount. But in the last column, you see that if they didn't go forward with the project, the city's only collecting $161,000 in revenue. And with the project, they're collecting $1,173,000, and that, that's with the abatement.
And then, of course, after the abatement burns off, you're collecting full taxes, so that you'll start to get that. And so part of your job, you guys have the hard job, is trying to figure out whether, but for the incentive, would it have happened anyway? I mean, and that's part of your duty to examine whether you think not giving, but investing your tax dollars, or abating them, any future tax dollars, whether this would have happened anyway. If it was happening anyway, maybe you don't do it and you just collect all the taxes for the city, county, and school board. But if you want to encourage it, you may determine that you need to give an incentive. And there are lots of good reasons to provide incentives. I don't have to tell your board that. Trying to attract a particular type of product to an area, and they may not have come but for the incentive, or sometimes it's difficult to develop a particular parcel. Atlantic Station we talked about earlier, that was a century-old steel mill that was shuttered with environmental hazards. No company wanted to come and take on the environmental risk to basically do the environmental abatement, put a cap on the it was a Superfund site. So they capped the Superfund site. It took a lot of incentive from Atlanta, Fulton, to do that. So those are reasons, you might choose to give an incentive because, you think it's just not going to happen if we as our community don't get active in encouraging it to occur. So just make that observation. So these, we've got more slides on documents. I really want to make sure we leave time to answer questions. So Ben, let me see. Let's see. Let's talk about clawbacks, and basically two things. We want to talk about two things. You've given an incentive, and you need to make sure that you're getting the benefit of the bargain. And so in the documents or in your policies that you adopt, you may choose to adopt, it describes when you will allow an incentive to be issued from the development authority. You ought to consider putting teeth in the documents and in the policies that say, if you don't show that you've actually delivered the new jobs, or you don't show that you've actually expended the capital in the community, or if you had say you told them that you were going to do a hotel and it's going to be at a particular level, if you didn't deliver on that level, then we're going to claw back, is the concept on that. That's a concept. The other thing that is always an issue is you got title to the property. And that means that if stuff goes down on the property, you're in the chain of title and you're going to get sued. So we've got our clients, many of our clients are just automatically, when a slip and fall case happens or a fair housing case is brought, they look at the chain of title and the development authority gets sued, as well as the developer owner. So insurance and indemnification are things that we have to structure for you. And it generally works out well. We simply tender the defense. The developer will indemnify the board, and we tender a defense, meaning that we transfer the responsibility for answering the lawsuit to the developer, and they have to answer for you. And you're named as an additional insured on all of their policies. And that's just one of the things that we simply, we require. And it comes up particularly when you do something that you might perceive as sort of being litigation target rich. You want to think, so, gee, well, how are we going to be protected? So that's one thing I want to do there. I'm kind of zipping through some of this because I want to be sure to answer questions, and we can come back and talk about any of the particular slides. Ben, what else? Oh, one thing, it's kind of now coming up a lot in development authorities around town, is that because Atlanta is what it is, and we're becoming a relatively expensive community to live in, a lot of communities are using this tool to attract workforce housing or affordable housing. And one of the things that I've seen done is that in addition to the jobs, you got to have the jobs. I think you did training just before we came on the statutory scheme by which you're created. And I suspect you talked about the fact that it's primarily for jobs. So everything has to be about jobs, but as Ben pointed out, you can add things to it. And a lot of communities are adding, if you do this for workforce housing, if you do this for housing, we're required to set aside a certain portion for workforce housing. And that may be defined as a percentage of the area median income set aside for those tenants. Or in some instances, communities are saying, you know what, we want to encourage housing for public safety workers. So we've got one community that has a set aside such that the units can be used for their community's police, fire, teachers, that there's some units that they get preferential first come, first serve preferential rates on to encourage that they live in the community that they're serving. So just another option. We're seeing a lot of that. So I wanted to mention it. But we're seeing a lot of that, not just in Atlanta. You know, probably hear Mayor Bottoms talking about workforce housing all the time, but a lot of the communities are doing that too, not just in Atlanta. So just wanted to make that observation. Ben, anything else? I just want to leave time. Usufruct, why don't you just describe, there's a variant on what we're talking about called a usufruct that we do want you to be aware of, because I say that because a developer may come to you and propose it, so.
Yeah. So we're on slide 19 at this point, just to make sure everybody's with us. And this, you know, as we said, Fulton follows a standard incentive methodology where year one is 50% abatement, year two is 45%, year three is 40%, you know, and it goes all the way down to zero until the company's paying full taxes. Not all jurisdictions do that. In particular, there's one kind of structure called a usufruct, which effectively allows the governmental entity to provide a much longer and much richer incentive to a developer. The theory behind it is that the lessee, the private company as the lessee, does not hold a leasehold interest. They hold a usufruct. And bond counsel kind of differs on whether this is acceptable or not. But generally it's been done, you know, in this state for a while. And the documents are structured such that the development authority as the owner of the property has more possession, more dominion, more control over the project than a typical estate for years lease purchase transaction. So you can put whatever you want in the lease agreement. You know, bond counsel has different kind of recommendations and advice on what they like to include. But the theory is that the more control that the development authority has on the project, the more it can kind of fall into this usufruct territory.
And let me just build on what Ben has said. So usufruct, U-S-U-F-R-U-C-T, it's a weird word. It's a real estate word. It's a word from it's real estate concept, usufruct. And it's just what Ben said, it's a non-taxable estate, it's an interest in land that is non-taxable because of it's such a limited interest. And so it's a couple of things about it. It is the law says that the interest that you have in real estate is determined by the intent of the parties, and then there are safeguards in the lease that will have one element of what it is the intent of the parties. The other element is just what Ben says, is that if a normal lease said that the that the lessee could determine the hours that it's open, in a usufruct, you might have describe it such that you can only have it be open from 9 to 10 and never on Sundays. So you in a usufruct, it's generally not even called a lease, it's called an operating agreement. So most usufructory interests are styled as operating agreements. And the more common of them are for projects that are really not even owned by, not really, think of it as really a project that's really not owned by the lessee. It's really owned by another entity. So the more common usufructs are like stadiums or convention centers, where even though you might have a private company that uses it every day, like the Falcons use Mercedes-Benz every day, in fact, the true interest lies with another party. And that's where the law, the lawyers that are drafting these things are drafting them in a way that they think if a court came in and looked at it, they said, well, the private party really doesn't have dominion and control over this asset such that we could say they have a leasehold interest. And so the lawyers are busy drafting little provisions in the documents in order to confer that concept that they don't really have an interest. And if you accomplish that, you can have a much different result in terms of taxation. And let me just describe what the result is. Usufructs, most often you'll see that if it's a usufructory interest, the private developer will pay zero taxes, zero. Any amount that they pay is a contractual payment, and that's generally styled with a pilot agreement, payment in lieu of taxes. So if you have the sort of the telltale, if you're looking at a usufruct, the developer will come and say, you know what, this is really a usufructory interest. It's not a taxable estate, but we will agree to make payments in lieu of taxes to the development authority, and the development authority's got to decide what to do with those taxes. You're either going to, share them with the other general purpose governments, city, county, school. You might have an arrangement that takes the pilot payment in and distributes it to them. Or sometimes you'll take the pilot payment in and you'll reinvest it in the project. We've seen a whole range of approaches to pilot payments. I will say that there was a deal in Cobb County that was done as a usufruct that was very controversial, because if you imagine a huge development comes and the school board wakes up and they realize, well, dang, we're not getting a single cent off of this brand new project. And they've challenged it. The result of which is that there is a new provision in the law called the Pilot Restriction Act that has now sort of limited the instances in which a development authority can take property, agree to a usufruct, have the developer make a payment to the authority, and then issue bonds secured by those pilots. So my only point is that usufructs are non-taxable estates, zero taxes. Anything that the developer pays is a contractual agreement that you and the developer agree to. And I will just observe that they have been controversial because for the other taxing jurisdictions, city, county, school, that may not be aware that you're doing a deal in which no taxes are paid, sometimes that can be controversial. And so it's generally, if you do it, it's for a select project that you've thought about and there really some other community benefit that's coming of it. I mean, there are instances in where it makes sense, but it's really the unique project that typically will be done with the usufruct. Most projects are not done with usufructs, but you will frequently, a developer will come and they're going to want the sweetest deal for themselves, so they may come and ask for it. But communities generally are reserving the use of that tool for something that's really transformational for a community. That's my only point, because you're getting zero taxes, and think about it, zero taxes, which means the city's still got to provide police service. If it produces any school-age children, the school board still got to find play to get extra capacity to service the community, and there's no offsetting income on taxes. So again, it's reserved for really special projects. Ben, I think I want to just maybe pause there and then just make sure that we address any questions that you have about these incentive transactions.
Okay. Director Jiggets, Director Pierce, Director Coleman, and do you have anybody else on the? No hands raised. Okay.
Thank you for your presentation, gentlemen. I would like to know if this, and I want to talk about community benefit agreements. Is that something we can dive into?
Sure.
Excellent. So, how deep how intricate can a development authority, does a development authority creates community benefit agreements with its partners, obviously the community developers, and how intricate can those agreements be?
I mean, for very large transactions that where you're giving up a lot in taxes, I've seen very intricate and involved community benefit agreements being negotiated. So just offering as one example, the project we're working on right now called the Atlanta Gulch, or Centennial Yards is the name of it, between Mercedes-Benz and State Farm Arena. There is a community benefits agreement that's embedded in a development agreement that requires the new developer to do a whole range of things, from providing new public facilities for the city of Atlanta. I've seen in Atlantic Station, we required the developer to build a fire station. There are, to get this, to induce the schools to participate, we had, they had to contribute toward the construction of what you may be familiar with, Centennial, I think it's a middle school that's right there by Coca-Cola's headquarters. So there are a variety of things that you, job training is another example. You can do, really, it's up to you. It's bound by the limits of your creativity, really. There's nothing that prevents you. Yeah, obviously you can't do anything that's discriminatory, but within accepting that, you can really limit it by your creativity in terms of what you think as a fair exchange for the incentive that you're giving the developer.
Got 2 questions. You
I yield for now.
2 questions. You say the term workforce housing. That sounds like, and I may be wrong, so I'm asking the question, it sounds like a nice way of saying low income housing. Are those one and the same?
Yes. I mean, yeah, it's affordable housing, workforce housing. So, it's, and people have done it. Many of our clients have different levels of affordability that they target.
Okay.
So we've
That's
seen.
the umbrella of the term workforce.
Right.
There's different levels of workforce.
That's right.
It brought it to me that I hate this, when I see on TV, they talk about food insecurity. It's just a nice way of saying people are hungry.
Right.
It's not insecure, they're hungry.
Right. Yeah.
Second question, thank you for answering that.
Yes, sir.
Use of right. So I looked up the word that you guys were talking
Yeah,
about.
weird word.
I'd heard the term, but
Okay.
so the definition is slightly different than your explanation.
Okay.
I think your explanation is probably more on point.
Okay.
So you gave.
What did Google say?
I'd have,
Okay.
about use of property, use of another person's property, but there was no mention of the denomination or taxes, nothing.
Oh,
Which is
yeah.
like the use of other people's property.
Yeah.
Which contextually from no taxes, that's kind of what it is.
Mm-hmm.
But, so you gave some examples of a stadium.
Mm-hmm.
So I think I know the answer to this, but I want to hear the answer.
Sure.
Why would a community enter into an agreement other than for an emotional connection to a football team? Why would we do that? No taxes on large parcels of land.
Right. So again, the result, the legal result of concluding that you have a usufruct is that there are no taxes. So that's where we start from, because it by definition is a non-taxable interest in real estate. So if you do nothing, the developer pays 0 taxes, but they're almost always accompanied with a pilot agreement.
Pay in lieu.
And that's where you say, okay, you're not going to have to pay. So we just described the normal ramp up schedule in Fulton County, which would be 50%. Right. If you decided it was a usufruct, then that gives you the flexibility to depart from that schedule. And this community might decide, you know what, for this limited project, we want it to be 0 taxes for 5 years. And then and maybe until the project is at substantial completion. And then after that, we're going to start ratcheting it up.
So 0 taxes is not in perpetuity. It could be constructed under a time period.
That's up to you.
Okay.
And again, I would say, a lot of this is, we're not talking about a specific project. So I'm giving you generic advice. If we were talking about a specific project, I would probably say this needs to be an executive session discussion. But we're talking generically. But generically, you should be aware that, there's not specific guidance in this. There's no statute that gives us specific guidance, number one. Number two, there's not a lot of case law on usufructs and taxation. There's not a lot of case law. So generally where it's done reasonably conservatively, so as not to, right. But we just don't have a lot of guidance on the main topic for today. There's a lot of guidance. We've got a number of Supreme Court cases that tell us how to do this. On usufructs, there's Georgia law. We don't have a lot that explains what the contours and limits and boundaries are for doing it. I can tell you what I've seen and what has happened in other communities and settings where it wasn't challenged and people seem to accept it. But I don't have a statute that I can go and pull out and say, yes, sir.
If I may, please. So, once upon a time, 2 years ago, there was a deal that was the usufruct was considered because a builder or developer reached out to us and they wanted to do business with our newly established development. When they reached out to us, somehow it magically ended up going to Fulton County because it never reached us first. So there was a consideration to salvage that project. And the usufruct was one of the things that came up in consideration. Mr. Selby used the term emotional.
I use the word emotional.
He said unless it was an emotional reason behind it. Now, I wouldn't say it was that kind of emotional, but as a chairman of this development authority, I felt the way about it because it ended up being redirected to the county. Now, in his description and the way that it works, there is some type of discretion on where those funds will go. The small percentage, if whatever, would come to this body. The taxes that would be considered, that would go to the school board as well as the county. We would have had at least the discretion to do it under a use. You follow what I'm saying? Now, it probably would not have been the best thing. It would probably appear desperate, but that may have been an option to regain said opportunity that should have come to us anyway. But yeah, I think that would have been one of those things. And in some cases, in a newly established municipality like ours, you do need all you can get, and it probably wouldn't have looked as bad, especially given this was the reach that this body that was established to do such deals. However, when deals go to, say, the county in your municipality, that same discretion on where and how much, goes to the county, the municipality, or the school board is subjective. And if, we all represent the city of South Fulton, and being a representative of the city of South Fulton, as well as a retired person who worked in the school board, there are several different disparities when it comes to county funds. Some funds go north, some funds come south. So it's not like we still would have that same type of discretion, but we would have had an opportunity to have a seat at the table to discuss further. You follow what I'm saying? Based off the structure of the city.
Absolutely. Thank you.
We have Directors Ivy and Miller.
Thereafter, Director Cole.
I got a few, I'm sorry. First question, if deal is structured the way that you've laid it out, obviously, and you mentioned, ownership of the land retains with the development authority, right? Who gets the depreciation? Because technically the improvements are owned by, obviously, the bondholder in this particular case. So who gets the depreciation? You can't depreciate the land, but you can depreciate the improvements.
Yeah, because the one element we did not describe, which is that the developer can cancel this at any time by prepaying the bonds. And we describe the bonds as phantom bonds, or bonds for which there really isn't a payment. The IRS has disregarded the lease for federal tax purposes. So it's recognized as a leasehold interest for state purposes, but it's disregarded for federal tax purposes. So the developer is still taking depreciation.
They are taking depreciation,
Correct.
which is good for the developer.
Right.
Got you. Okay, so now next question. In these examples, right, we continue to sort of highlight the real estate construction involved with a number of these projects, the stadium, the whatever. But at the same time, you know, if we think a little broader, this is easily also financing a business as a whole. It just is, right? It very well could be, right? Because it's the hotel, right? So if you've done that, do you see convertible bonds or clauses that are convertible to equity also included from your side? You may not, but I couldn't help but to ask that question.
So, you know, these bonds I've never seen these bonds get actually monetized in any way.
Okay.
Your authority certainly has the power to monetize them, to monetize a bond for a developer, but these bonds have not been monetized. Tell me what's your idea? So you're thinking that from the developer that they may want to help me to understand what you think the business
I'm saying in this
objective would be.
case, let's say you've got a third-party developer that's, you know, they're going to build some structure and then, like you say, lease it out themselves or do whatever. But let's say there's another example where the developer of the property intends to use the property themselves, right? And let's say it's a startup. I mean, this is a startup business. So again, my next question goes to clawbacks, but the clawbacks mitigating risk. So would the convertible bond. Well, fine. You've not paid, you've not performed, you've not done X, Y, Z. We've reasonably just financed your entire operation. Why would we not ask for, or is it typical to ask for bonds convertible to equity? Now we've got the property and the business.
That's an interesting idea. That's an interesting idea. I've not seen that. Like I said.
Oh, you got to send me a code now when you do it.
The limits,
my question.
the limits are your creativity, and I see there's a lot of it here. But no, I've not seen. I see your point. You're saying you didn't perform. Exactly. Therefore, the bond is now convertible to equity that this development authority has in your business.
Exactly.
Yeah, I've not seen that. I've not seen that. People tend to bifurcate the arrangement and focus on the lease purchase, bonds for title, whatever label you want to put on it, as being merely a tool of conferring a tax abatement. And that the remedy for failure to perform is a loss of the abatement. You're suggesting that there could be other enhanced remedies, like equity in the business or some kind of
assets, everything, whatever it is.
Yeah. Now, mind you, these companies are, when they do an abatement, if it's truly startup and if they're not paying cash, we have some clients that do it all cash, like Tyler Perry. Tyler Perry did an abatement, but his was all cash. There was no mortgage on his project. So, yeah, but most of he's okay. It was all cash with him. But most of them have mortgages. So there's going to be another player at the table that the development, that's sort of looking at the development authority and asking that you subordinate all of your interests to the lender.
But again, the mortgage is on the land
Right.
and in theory, the improvements.
Right.
I'm talking the business and the asset.
Yeah.
We don't have to get into it,
Yeah.
but you see what I mean?
Yeah, it's an interesting
So-
idea.
so-
I've not seen that.
So next question, just the clawback, just the mechanics of the clawback. Clawback's obviously mitigating risk. Is that, so then is clawback the collection of mitigation clauses scattered through all documents? Is there a specific document that mitigates the risk? How's that structured?
Yeah, so we'll have a lease that will attempt to define what your community benefit you're asking for. It's typically three things. It's capital expenditures in your community. It's jobs. You know, most people it's jobs. They want to know your applicant may say, we think our project's going to create 100 construction jobs and then X many permanent jobs. And sometimes people will negotiate at this average wage, and you will then have a reporting regime where they have to report to you annually. And to the extent that they depart from that, you have the ability to say, we are some proportional way reducing the incentive that you
Sure.
get. That's the clawback.
But again, where's that? But where's that verbiage? Is
In the
that
lease.
verbiage a number of clauses that are scattered through? But you just said
It's in the
okay, so
lease.
it's specifically in the lease is
Yeah.
where it normally would go.
Yeah, that's in the lease.
Gotcha.
That's
Last
in the lease.
thing,
Yes,
memo
sir.
of agreement, is
Yeah.
that filed alongside where title would be?
It's typically not recorded. It's not recorded in the real estate records.
Okay.
It's just a contractual arrangement so that everybody gets comfort that when that developer gets their tax bill, that it will reflect
Gotcha.
the agreement.
So would any of this be recorded that you
Yeah.
just talked about?
Yeah, no, we're going to record
lease itself.
we'll record a memorandum of lease in the real estate records. Not the memorandum of agreement with the tax assessor.
I got you. The
We'll
memorandum of lease. I got you.
record a memorandum
I got
of
you.
lease.
I
Yeah,
got you. Which would stop which would stop the folks that have retained ownership typically from encumbering the property, right? Because you just leased it out. You can go take out another mortgage or do whatever you want. And so showing that recording the lease would typically stop you from doing that. The bank's gonna say, wait a minute, you can't do this or that because you caught it. Thank you.
Yes, sir.
How you doing?
Director,
Thank you very much. Mr. Shelby, I want to first of all thank you because I had the pleasure of seeing you actually give a presentation before, and the second time has just been greater than the first time. So thank you very much for the opportunity to hear your presentation. My questions are as follows with regard to slide number 8 with the memorandum of agreement. You mentioned that Fulton County generally signs them, and some assessors do not. And I just wanted to understand do you know what the rationale is behind that? And also with regard to the validation document process with Superior Court in the state of Georgia. I think you just mentioned that the state of Georgia has that. I don't know if that's reflective in other areas. I do have a question after that though as well.
Okay, thank you. Thank you, Ms. Miller. Ivy, Ms. Ivy.
Thank
I
you.
see there's another guy. So my sense of it is that the reason that certain boards of assessors do not sign the memorandums of agreement is that there's nothing statutorily that requires them to, and we've came through a period, particularly in Metro Atlanta, where these transactions were getting challenged by some pretty aggressive taxpayer advocate groups. And it's my understanding that the discretionary act of signing the memorandum of agreement was viewed as getting the members of the Board of Assessors involved in some, just if I can use be colloquial for a moment, just some mess that they didn't have to be involved in. And so we had an instance where there's one guy in Fulton County that was really a sort of a repeat offender in terms of intervening on these bond issues. And he would go so far as to subpoena individual members of the Board of Assessors to show up at the validation hearing. And I think their counsel just sort of got to a point where they said, you know what, there's nothing that requires us to sign this. The developer knows what our approach is. The development authorities know what our approach is. If we're not required to sign it, we're not going to sign it. And that's the position of at least DeKalb County. So unless Calvin Hicks, who's the chief appraiser of DeKalb County, does not sign memorandums of agreement, we've been able to get them to do some modifications, but as a general practice, he does not. Neither he nor his board will agree to sign them. That doesn't mean that they won't do their job, which is to find a taxable interest and assess it. They still do their job and the end result is the same, but we don't end up with a signed document. A lot of times the signed document, to be honest, gives the developer and their lenders comfort, because the lenders are running a cash flow analysis of how much can this developer afford to pay in a mortgage or a loan. And one important factor of that is how much is their tax liability. And a lot of times they take comfort from a signed document. So fortunately, since you're in Fulton, the chief appraiser in Fulton will sign an agreement as long as we use the agreement format that they signed off on generally as a Board of Assessors. The second question about, sorry.
No, go ahead, please.
The second question about validation. Yeah, so this is, Georgia is unique. The state of Georgia is unique in that all bonds, with limited exceptions, must be validated before the Superior Court. Other states, it's not compulsory, and in some other instances, it's voluntary, and most people only go and validate transactions that are kind of at the edges of the law. But in Georgia, every bond issue, with some limited exceptions, tax anticipation notes being one of them, that the city of South Fulton does. You don't have to validate those. Everything else has to be validated, whether it's a lease purchase, a simple lease purchase, or a simple general obligation bond issue from the city. Everything has to go before the court. And it's not a big deal either. So the fact that you've got this requirement, it's generally, Ms. Walker has done them with me before. It's generally a perfunctory process if nobody challenges you. So it's a little more paperwork, but it's really not that big a deal. It's not really like adversarial litigation or anything like that. The courts generally take it in. We go and have a hearing. It takes 5 minutes and we're out.
Okay. So 2 other questions and I'll yield the floor. On slide number 9, you mentioned a statute regarding the Kroger case, and I just didn't get the statute number, and I just wanted to have that for my personal records.
Yeah.
And in addition to that, my last question.
Yeah. Okay. Yeah. So yeah, Ben mentioned the provision in the Development Authorities law that's the definition of project.
Yes.
And do you have the site?
I believe it's 30, you'll have to fact check me on this, but I believe it's 3662-26N.
N is in Nancy. Yeah.
Thank you.
And it's the final clause under the definition of project. And it was added after, you'll see when you look at the statute, it's got a bunch of descriptions of what development authorities can do. And then finally, I think the General Assembly got tired adding every little thing and they just threw in a paragraph in. It's a catch-all. And that's what most development authorities go under for most of their projects.
And rather, this is a comment. I'm so glad that when you talked about the clawback, instances that you mentioned the indemnification issues, because I think that that's just good for us to have as a body, just to understand, all of that and what that entails in a deeper dive as you've gone through. And I certainly appreciate your presentation and all of the comments. I yield the floor. Thank you.
Thank you.
Thanks, Director. Director Miller is up next, and then we have Director and we're gonna close out.
Okay, first of all, thank you for the presentation. It was great. I have two questions. My first question is, should we, in your expert opinion, should we as a board kind of save our abatement for companies that are coming with higher job creations? That's one. And my other question is, can we require that they hire a percentage of employees from that community? That's it. Thank you.
Well, I will say with respect to the, this is not a necessarily, my observation is that the statute requires that you approve projects that advance trade, commerce, and industry and employment opportunities. So that, you'll need to, in order to comply with your duties under the statute, it will need to be that a finding along those lines. So yes, I think that jobs generally have to be an important element of your decision. If you were financing something that created 0 jobs, I would suggest that may not be in keeping with this statutory scheme that the General Assembly has set out for you when they created development authorities. I think I heard you also say, high wage jobs. That certainly is something that's in your discretion. I have seen projects where an important factor in whether an abatement was granted was the average wages. And I've seen in documents a monitoring of the actual wages. And then I've seen clawbacks tied to whether in fact they performed. And the lawyers will get into it and they'll say, what happens if something unexpected occurs? Do you have discretion to waive the requirement? We call it force majeure or an act of God. Economic recession. We'll have provisions that give you flexibility, but I certainly have seen that. What was the other question? Is that it?
Okay, it was not so much wages, but can we require that they hire so many people from that community?
Yes, ma'am. I've seen that. For instance, in Atlanta, we require use of WorkSource Atlanta as a first source of identifying people to work in the whatever facility or project is being done. So the developer will be required to utilize that mechanism of employing people in the project that's just received an incentive from your community. Not just jobs, but also use of local vendors, small and minority business requirements and compliance and use of best efforts to achieve that. There is some law around, and your general counsel will probably be able to better help you there, but around when you can have a affirmative action goal as to whether you have a disparity study on the books. But I have seen the contracts will ask the developers to voluntarily agree to use best efforts to do that. In terms of whether you can require it, that's going to depend on the law on that, and whether, I don't know whether South Fulton has a disparity study. Okay. So, but those are common. Again, the limitation is really your own creativity, which a lot of us in this room. But that certainly is not, that's a common feature. Local jobs is a common feature.
Thank you.
Yes, ma'am.
And we're going to wrap up with Director Diggins. But first, I just wanted to ask, how close is that to discriminatory violence?
Which one?
When it comes to hiring people from the immediate area of the municipality.
That's not a protected class. So if you have a preference that you give a preference to local folks, you're not discriminating against a protected class of people. Yeah.
So nobody has ever challenged that. In the city of South Fulton, we're 90% African American, and blackest city in America for the national city. So when you have stuff like that, has that ever been a situation? Or, could you foresee something like that?
Yeah, I mean, listen, lawyers will sue over anything.
I remember that you said you can structure your deal however you want to,
Right,
as long as you're not discriminating.
right,
And so when Director Miller brought that up, it just made me think
Right.
about that for a second.
right,
Possibility.
right. I mean, local hires is a neutral.
Let's stop, because
Okay.
I don't want to
Yeah,
encourage nobody.
Yeah. Okay,
Go ahead, Derek.
No, I want to say thank you to my colleague, Dr. Miller, because when I brought up community benefits, that is the framework in which my mind is working, and you expanded on it, Mr. Shelby, as it pertains to contractors and workforce. I think those two things are in the wheelhouse of what I want to hear. But I understand that the disparity of the study would, once the city has one in place, if I'm not mistaken, that will give us the sort of the backbone by which we can fight against losses. Am I mistaken on that?
that's not my expertise, I'm gonna defer.
Am I?
Yeah.
This is for the discrimination piece.
Like if we had the study in place, it will sort of be a tool by which it would not be.
It would still not be, but it's based on Georgia where Fulton County has had the disparity study in place, and they still have lawsuits about it.
Well,
But it will significantly lower a lot of.
Right, and that's-
challenges that will come against you without the study.
because anybody can file.
Right, because you can require a set aside in your contracting if you have a disparity study versus here, you might, say a factor in whether we would grant an incentive is if you voluntarily agree to use your best efforts to provide diverse, but if you have a disparity study, you can require in your contracting that is, there's a case that describes it all, and it, depending on, which administration federally is in place, that gets challenged from time to time. But that's generally the law. You need a disparity study to require it.
My next question.
Yes, sir.
Is there a general list of policies that exist? I know we will create our own, but they're in the development authorities. Are there pre-existing somewhere we can go and look at a list of policies that other similar agencies adopt for success? Again, I think it was Director Miller, when she asked about like the number of people. That would sort of be like the policy that we would establish in the body, and as we grow our organization, does that exist somewhere, something we have a blueprint of policy that exists that give us a general idea on whether we go left or right, and we make our own decisions.
Yes, there are some of your peer authorities do have policies, and that they're public, so we could share them.
I just think that would be important as we, are embarking on something some of our neighbors have done, give us a good point of reference on what they become work has not worked.
Thank you so much.
You're welcome.
Mr. Selby, and, I'm sorry.
Vernon.
All right, thank you so much. We really appreciate y'all.
All right. Thank you.
Thank you, guys. Thank you, Mr. Selby, for being greater than you were the first time. I heard you. It's always a pleasure.
Neil, do you want to talk about the project at all?
Yeah, I think we take.
Well, we're gonna take a 15-minute recess, and then we get back in. I think her portion is a little shorter than. 15 minutes. Let them know. We'll take a 15-minute recess, and then we will start the next presentation.
145.
1:45. 1:45.
Thank you so much.
No, they do it. Yeah.
and they have.
But I don't want that because they have.
It's not a bulletproof. You know what I mean? Just gonna make it sound.
Yeah.
I think they will be better.